Contract is an object of people's will. Mark P. Jurgen. The American Journal of Jurisprudence, Volume 70, Issue 1, June 2025. Abstract. This paper takes a simple definition of consent from the law of Battery. Consent involves a conscious choice to show that consent so defined plays a crucial but necessarily limited role in contract law. Contract generally does flow from a conscious choice, or at least its appearance, but this is necessarily true only with respect to aspects of a transaction that people think and communicate about when they make a contract. The most important objects of consent, so defined, in contract law are consent to engage in a bargain exchange transaction and consent to a writing as an expression of terms. Because people can be expected to have these objects in mind when they make a contract. Terms themselves are an object of consent when people think and communicate about them, but often they are not, as in a predictably unread term in a writing. Defining consent in this way reveals that the apparent consensus that contract turns on objective intent is misleading, for people use the term to mean two very different things. Some people define objective intent as apparent intent, while others define it as intent indicated by a rule or a convention, even when the other party knows or should know the first party's true intent. Indeed, this is the major point of difference between classical contract law and modern contract law in the rules that give legal effect to a writing. Finally, the paper argues that the fact that intent includes terms that go without saying is not a reason to reject a simple mentalistic definition of intent for the purposes of legal analysis. Terms that go without saying will be picked up by a rule deriving terms from context, along with other terms derived from context that would not be described as intended or as intended in this way. This is an open access article distributed under the terms of the Creative Commons Attribution License, which permits unrestricted reuse, distribution, and reproduction in any medium, provided the original work is properly cited. Introduction. The importance of people's will in contract has been argued about for centuries. The will theory asserted that contract flows from people's will. Classical contract law rejected the subjectivism of the will theory and asserted that contract flows from objective manifestations. Lon Fuller partially rehabilitated the will theory in the mid-20th century, arguing that contract ideally flows from people's will, but that institutional and fairness considerations sometimes require sacrificing this ideal. More recently, autonomy theories of contract put at the center of contract an act of people's will that is variously described as promise, consent, transfer, or choice, but they disagree about the mental state required. Meanwhile, in the debate over the legal status of boilerplate terms in consumer form contracts, some argue that the absence of consent requires that predictably unread terms not be enforced, while others argue that the impracticability of obtaining consent to such terms shows the naivety of thinking that contract could flow from consent. This paper borrows a simple definition of consent from the affirmative defense of consent in the law of Battery to show that consent so defined plays a crucial but necessarily limited role in contract law. The definition is tailored to interactions between people that would be a battery absent consent, such as an intimate touching. Under the law of Battery, a plaintiff consents to a touching if they are consciously willing for a touching to occur. It follows from this definition that apparent consent means that the defendant reasonably believes the plaintiff is consciously willing for a touching to occur. There are reasons to be skeptical about whether this simple definition of consent can be applied to contract law. O'Regan argues that, if the concept of consent is to play a role in contract law, then the concept must be gradual, nuanced, and socially constructed, and that consent is better understood as a continuum. Randy Barnett argues that people's silence in the face of default rules constitutes indirect consent to a rule, so long as the transaction costs of discovering and contracting around a rule are sufficiently low. Brian Langill and Arthur Ripstein argue that the fact that people are understood to intend things that go without saying shows the naivety of a simplistic mentalistic definition of intent, and that communicated intent, that is, meaning, is always social and contextual. And Tess Wilkinson Ryan finds that lay people say that they consent to unread terms in form contracts. The central claim of this paper is analytic. Adopting this definition shows that consent plays a crucial but necessarily limited role in contract law. Consent, so defined, plays a crucial role in contract law because contract generally does flow from people's actual or apparent consent, or from a related mental state, intent, choice, or belief. With respect to aspects of a transaction that people think and communicate about when they make a contract. But consent, so defined, necessarily plays only a limited role in contract law because people do not think and communicate about many aspects of contractual transactions when they make contracts. The error of the will theory was that it ascribed too much significance to people's will. Contract can flow from people's will only with respect to aspects of a contract that people think and communicate about when they make a contract. The error of classical contract law was that it ascribed too little significance to people's will. Contract generally does flow from people's will when people think and communicate about an aspect of a transaction when they make a contract. This clears up widespread confusion about the place of consent in contract law. Nate Oman argues in a recent paper on the place of consent in contract law that consent is less normatively important to contract law than many contract law theories assume, and that no single, normatively consistent vision of consent drives contract law. Oman does not see the crucial importance of consent, as I define it, in contract, because he is attracted to the view that contracts should flow from consent to create legal relations. This cannot be the object of consent as a general matter, because people often do not think about legal consequences when they make a contract. The object of consent must be something people think and communicate about when they make a contract, or at least something the law can require people to think and communicate about. Consent, or at least its appearance, generally is at the heart of contract when it comes to aspects of contracts people think and communicate about when they make contracts. Oman's mistake is to demand more than this in the way of consent. This paper will not adjudicate disagreements about why consent is important. Some theories take the position that consent is intrinsically important. On this view, when an actor consents to a change in their legal or moral position, they may not complain about the change because they consented to it. Heidi Herd nicely captures this way of thinking when she describes consent as moral magic. Other theories treat consent as instrumentally important. Under economic theory, consent is important because of what it reveals about people's preferences, and because consent is an important element of private ordering when private ordering is the best mechanism for allocating resources and structuring human interaction. Disagreements about why consent is important matter. If you believe that consent is intrinsically important, then you would draw a sharp line between actual consent and apparent consent. There is no magic in apparent consent. It is given effect for other reasons, which must be sufficiently strong to warrant treating a person as consenting when they did not. Often, it is given effect to protect another person's reliance on apparent consent. On the other hand, if you believe that the purpose of contract law is to facilitate commerce, then you would draw a less sharp line between actual consent and apparent consent. And you would be willing to treat intent indicated by a legal rule as final, even if the party's intent is otherwise, in the interest of certainty and finality and to facilitate commerce. Section 2 sets the stage. It explains the definitions of actual and apparent consent in the law of Battery and compares the concept of objective consent in contract law. I show that the adjective objective before a mental state is ambiguous. Modern contract law, for example, contract law today in California and under the restatement second of contracts, generally equates an objective mental state with an apparent mental state, while classical contract law, for example, contract law today in New York and Texas and under the first restatement, generally equates an objective mental state with a mental state indicated by a legal rule or a social convention. These different definitions of an objective mental state yield different results when a party fails to comply with a rule or convention on how to express their mental state regarding a contract, for example, put it in writing. But the other party knows or should know the first party's actual mental state. Section 3 applies my definition of consent to the law of contract formation. Section 3. A uses the rules governing simple implied contracts to show that the most basic object of consent in contract law is to choose to engage in a bargain exchange transaction. Section 3. B turns to the rules governing contract formation in more complicated cases. These rules show the necessarily limited role consent plays in contract law. Indeed, they deserve much of the blame for muddying the role of people's will in contract, because, under these rules, actual or apparent consent, or a cognate mental state, can be neither sufficient nor necessary for a contractual obligation. An actual or apparent choice to engage in a bargain exchange transaction is necessary, but not sufficient to make a contract, because additional requirements are imposed. There are good reasons for this, including shielding people from unintended contracts. On the other hand, once a contract is made, a person may be held to a term without actual or apparent consent. This is inevitable because the law must provide terms to cover matters people do not think or communicate about in making contracts. Section IV applies my definition of consent to rules that determine the legal effect of a contractual writing, the duty to read rule, the parole evidence rule, and rules for interpreting writing. These rules make a writing the second most basic object of consent in contract law, after the choice to engage in a bargain exchange transaction. By giving legal effect to terms in a writing when people consent to a writing as an expression of terms. These rules are where classical contract law and modern contract law most clearly ascribe different meanings to the term objective intent. Classical contract law often gives strict effect to a writing, even when the writing does not reflect one party's intent, and the other party knows or should know this. Modern contract law is more willing to look past a writing to give effect to a party's actual intent, whatever the writing may indicate, when the other party knows or should know the first party's actual intent. These rules also show the necessarily limited role consent plays in contract law. Under both modern and classical contract law, a person who consents to a writing may be held to a term they were unaware of, and so did not consent to, as I define the term. Section V addresses an objection to my simple mentalistic definition of intent. The objection is that this definition does not account for the fact that, in communication and contract, people are understood to intend things that go without saying, such that a more capacious definition of intent is needed to account for implied terms. I argue that the fact people are understood to intend things that go without saying is not a reason to reject a simple definition of intent for analytic purposes. Things that go without saying will be picked up by a rule deriving terms from context, as well as implied terms that would not be described as intended or intended in this way. 2. Consent in the law of battery and in contract law. This paper takes the definition of consent from the affirmative defense of consent in the law of battery and uses it to explain the role of people's will in contract law. The definition is tailored to deal with intimate interactions between people, as in Pauline's case. Sexual bull Boris, on his first date with Pauline, suddenly kisses her fervently, and continues to do so despite her repeated and clear verbal protests. Boris hears her protests but ignores them because he subjectively believes that her protests are insincere, and that she actually consents. Boris's fervent kissing is tortious, unless Pauline actually or apparently consents to being kissed. For there to be actual consent, Pauline must consciously be willing for Boris to kiss her fervently. For there to be apparent consent, Boris must reasonably believe that Pauline is consciously willing to be kissed fervently. In other words, apparent consent means apparent actual consent. Crucially, the addressee Boris must reasonably believe that the addressor, Pauline, consciously consents. For actual or apparent consent to be legally effective, there must also be no vitiating circumstance, like incapacity, duress, or mistake. This paper does not address vitiating circumstances. Actual consent is a conscious mental state. The restatement, third, of torts. Intentional torts to persons describes the plaintiff as having the requisite mental state if the plaintiff is willing for the defendant's act to occur. Other possible descriptions include where the plaintiff chooses for the defendant's act to occur, or the plaintiff intends for the defendant's act to occur. I use the terms consent, intent, choice, and belief to refer to a conscious mental state regarding an aspect of a contractual transaction. The prefix actual is superfluous before a mental state, but I sometimes use it for clarity or emphasis. The prefix apparent before a mental state means a reasonable belief in the appearance of this mental state. I will return to the difference between the battery law concept of an apparent mental state and the contract law concept of an objective mental state. Defining actual consent as a conscious mental state requires that the object of consent always be defined by reference to an object that people can be expected to have in mind when they consent. An object that is not mentally immediate cannot be an object of consent if consent is defined as a conscious mental state. Thus, legal enforceability cannot generally be an object of consent so defined for contract, because people often do not have this object in mind when they make contracts. And one would never say that people actually or apparently consciously consent to predictably and read terms in a writing, though one could say people consciously consent to a writing as an expression of terms. Because people can be expected to have this in mind. What the law requires in the way of a conscious decision to change one's legal position with respect to another person depends on the character of an interaction with that other person. In Pauline's case, tort law defines the object of Pauline's consent in very specific terms. The specific act and touching that occurred. Consent to a light kiss on the cheek is not consent to a fervent kiss on the lips. If a touching is very intimate, Not only must the plaintiff be willing for the specific conduct and touching to occur, but the law may also require that the plaintiff affirmatively communicate this willingness to the defendant. Consent to a contract can require much less in the way of thought and communication than consent to an intimate touching. People can make a contract by choosing to engage in a bargain exchange transaction without giving any thought to the terms of the exchange. And people can submit to contract terms by consenting to a writing as an expression of terms without giving any thought to the terms of the writing. A choice to engage in a bargain exchange transaction is a choice to engage in a general type of human interaction. Consent to a writing as an expression of terms is consent to a legal form. Contract law must enable people to engage in contractual transactions with very little thought. For some contracts warrant very little thought. Hanoch Dagan and Michael Heller refer to such contracts as errands, meaning exchanges for mundane things that people want to accomplish with as little thought as possible. But contract law should place no less value than the law of battery on people's will when people do think and communicate about an aspect of a transaction because it's important to them. Happily, this turns out to be true, particularly under modern contract law. However, contract law approaches the issue of consent very differently from tort law. I turn to contract law now. It is a fundamental axiom of US contract law that contract flows from manifest assent. Thus, the restatement, second, defines a promise as a manifestation of intention to act. A bargain is requiring a manifestation of mutual assent to the exchange. An offer is the manifestation of willingness to enter into a bargain, and an acceptance is a manifestation of assent to the terms thereof. A consequence of this position is made explicit in the rule on when conduct manifests assent, which provides that the conduct of a party may manifest assent even though he does not in fact assent. I set aside two possible points of difference between contract law and the law of battery about what constitutes consent. One difference involves cases in which actual consent is not communicated to the party claiming consent. The restatement of intentional torts to persons takes the position that actual consent is effective, even if consent is not communicated to the party claiming consent. Contract law takes the opposite position, that consent must be communicated to be effective. An explanation for this difference is that contract requires agreement, which requires that consent be communicated. The other possible difference involves cases in which apparent consent is not based on the actions of the apparently consenting party. The restatement of intentional torts to persons takes the position that apparent consent need not be based on the words or affirmative conduct of the plaintiff. Contract law clearly rejects this position. Thus, apparent agency, which can give one person the power to bind another person, must be based on words or affirmative conduct of the putative principle. My interest is the different ways in which the two bodies of law handle cases where the addressor, the plaintiff in a battery case, does an act that conventionally connotes consent, but without intending to consent, and the addressee. The defendant in a battery case knows or should know that the addressor does not consent. That is, cases in which the reasonable belief requirement might seem to be satisfied but is not satisfied, because the addressee knows or should know the addresser's state of mind. Cases like this are unusual in the law of battery. The restatement of intentional torts to persons contrives. Tony's case. Tony enters a crowded bus and loudly shouts, "Keep your distance. Do not touch me." The bus driver announces, "Please move to the back of the bus to make room for other passengers." Ben, despite hearing Tony's statement, squeezes past Tony towards the back of the bus, brushing against Tony. Most people in Tony's position would not object to Ben's contact, but Ben knows or should know that Tony does object because of Tony's shout. The restatement of intentional torts to persons handles this case with a special rule of non-liability for minor contacts that are clearly socially justifiable. The comment explains that only a small handful of cases will be affected by this special rule of non-liability, because other tort law doctrines, for example, requirements of offensiveness or lack of consent, will usually preclude liability in cases similar to the illustration. Cases like this are ubiquitous in contract law, particularly under classical contract law. Again, some states, like New York and Texas, still apply classical contract law. Consider Mitchell v. Lath. Mitchell and Lath sign a purchase and sale agreement for a home that does not include Lath's promise to Mitchell to have an ugly ice house on adjacent land moved. Under classical contract law, the promise is unenforceable under the parole evidence rule, even if Lath knows that Mitchell believes the promise to be part of the agreement. The parole evidence rule and a convention of putting contract terms in writing establish the appearance of consent by the addressor Mitchell to a contract to purchase the home without a promise to move the ice house. But the addressee, Lath, knows or should know that Mitchell does not consent. The requirement for apparent consent that the addressee believe consent has been given is not satisfied. The result in Mitchell v. Larth is a byproduct of a rule that instructs people how to make a contract. Mitchell does not do what the parallel evidence rule instructs her to do to make Larth's promise to move the ice house part of the contract, that is, put it in writing. As a result, Mitchell is trapped in a contract that Mitchell did not consent to. And this is the result even if Larth knows or should know that Mitchell believes that the promise to move the ice house is part of the contract. Williston would have agreed with these factual claims, but he would have said these facts are irrelevant under contract law, because contract flows from objective intent and does not require actual intent. On Williston's view, when people engage in an interaction that is subject to contract law, they submit to a system of rules that enable people to make contracts and set terms. Objective intent is determined by applying these rules. This approach is epitomized by Williston's position on how courts should interpret a writing. The first restatement of contracts explains that, where people integrate their agreement, they have attempted more than to assent by means of symbols to certain things. They have assented to the writing as the expression of the things to which they agree. Therefore, the terms of the writing are conclusive. And a contract may have a meaning different from that which either party supposed it to have. Modern contract law, for example, the law in California and under the restatement second, reaches a different result in Mitchell v. Larth. Mel Eisenberg has described the approach of classical contract law to interpretation as entirely or almost entirely objective, contrasting modern contract law, where the standards include important subjective elements. While modern contract law has rules that instruct people how to make contracts, it takes a more tolerant approach when people fail to obey these rules. A party who fails to obey a rule will lose if the other party reasonably believes that a rule accurately reflects the first party's mental state. But the other party may not take advantage of a rule if the other party knows or should know that the rule does not accurately reflect the first party's mental state. I return to this point in section IV after I address the role of people's will in contract formation. 3. The law of contract formation. Most accounts of the law of contract formation treat an exchange of promises, typically by offer and acceptance, as the exemplar contractual type. The role of people's will in contract formation is clearer if we treat a simple implied contract as the exemplar contractual type. A simple implied contract requires no less and no more than an actual or apparent choice to engage in a bargain exchange transaction. The more complicated rules that apply when people try to make a contract by an exchange of promises, for example, offer and acceptance, show that consent, as I define it, necessarily plays a limited role in contract. Under these rules, consent is neither sufficient nor necessary for a contractual obligation. Actual or apparent consent is not sufficient for a contract to exist, because, for a contract to exist prior to performance or perhaps reliance, contract law imposes requirements in addition to consent to engage in a bargain exchange transaction. These additional requirements are imposed for good reasons, including protecting people from unintended obligations based on apparent consent in the absence of performance or perhaps reliance. Once a contract exists, people may be held to a term without actual or apparent consent. Again, there are good reasons for this, including supplying terms to cover matters that people do not think or communicate about when they make a contract, and resolving disputes when parties intend different terms and neither party knows or should know the other's intent. Simple implied contracts. This section concerns the role of people's will in the rules that govern simple implied contracts. These rules apply when a contract is based on people's actions and not their expressions. They establish the bare minimum of what the law requires in the way of a mental state for a contract to exist. This is no less and no more than an actual or apparent choice to engage in an interaction with another person that the law treats as contractual. Specifically, the law requires an actual or apparent choice to engage in a bargain exchange. This for that transaction. Nothing less than an actual or apparent choice to engage in a bargain exchange transaction is required for an implied contract. Lending a hand. Alex and Chris are domestic partners. Alex occasionally lends a hand in a business owned by Chris, doing things Chris would naturally pay for if Alex were a stranger. There is an implied contract, but only if Alex intends a bargain exchange and not a gift, and if Chris should reasonably understand that this is Alex's intent. Focusing on Chris's actual or apparent state of mind, Chris consents to pay for the help if Chris believes the interaction to be a bargain exchange. That is, Chris intends to pay for the help. Chris apparently consents to pay for the help if Alex reasonably believes that Chris intends to pay for the help. Nothing more than an actual or apparent choice to engage in a bargain exchange transaction is required for an implied contract. Mistaken gardener. Gardener is hired by homeowner's neighbor to pull weeds. Gardener mistakenly pulls weeds at homeowner's house. Homeowner sees gardener as gardener is beginning to work, but homeowner says nothing. There is an implied contract because gardener reasonably believes homeowner chooses to engage in a bargain exchange transaction. The fact that gardener and homeowner do not have a price in mind and do not know each other's names does not prevent an implied contract. Classical contract law muddies this simple point by imposing additional requirements for a contract claim. Under classical contract law in mistaken gardener, gardener's claim for payment might well have been in restitution or quantum meruit, because the absence of an agreement on price would preclude a contract claim on the ground of indefiniteness. Do not let the claims label confuse you. The fact that homeowner actually or apparently chooses to engage in a bargain exchange transaction means that gardener has a right to be paid a reasonable price for the work, even if the work does not benefit homeowner. On the other hand, if homeowner does not actually or apparently choose to engage in a bargain exchange transaction, for example, homeowner is away from home when gardener does the work, then gardener must establish that homeowner benefited from the work and would be unjustly enriched if homeowner were not required to pay for the work. A choice to engage in a bargain exchange transaction is a general type of choice. The law generally and crudely divides private interactions involving a transfer of services, money, or property into either bargain exchange or gift. The object of choice is to engage in one of these two general types of interactions. Cases like lending a hand are a problem because transfers within families and between friends are often made on a communitarian basis, so a transfer does not fit within the legal categories of gift and bargain exchange. Ambiguous cases are handled by presumptions and default rules. For example, a transfer of money is presumed to be an interest-free loan, and a transfer of property is presumed to be a bailment and a gift of the use value. Unless there is clear and convincing evidence of intent to make a gift of the principal or property. If a transferee cannot overcome the presumption and establish that there was a gift of the principal or the property, then the default rule is that the transferee must return the principal or the property to the transferor. But the transferee does not have to pay interest or rent for the use value. B. Express contracts. Turning from the rules that apply to simple implied contracts, what follows legally from a choice to engage in a bargain exchange transaction depends on how deeply people become engaged in a transaction, what people think and communicate about with respect to terms, and whether one or both parties transmit a writing with terms. Generally, when people choose to engage in a bargain exchange transaction, there is an obligation to pay the market price for the performance rendered. But sometimes this is not true. If people intend different prices and neither apparently consents to the other's price, then a court will hold that the contract fails because of a mutual misunderstanding regarding price. And a claim for performance rendered will be in restitution and benefits based. If people are deeply engaged in a bargain exchange and one or both transmit a writing with terms, a court is likely to find that there is a contract and look to the writing S to define terms. This takes us into the common law mirror image rule, the common law last shot rule, and UCC section 207. I will return to these rules shortly, for they illustrate that a term can become part of a contract without actual or apparent consent, and sometimes even when a party intended a different term. It follows that an actual or apparent choice to engage in a bargain exchange transaction is necessary, but not sufficient for a contract to exist under the rules of contract formation. This mental state requirement for a contract is like the requirement that, for a gift, a person must intend to make a gift. For a gift, the law requires, in addition to donative intent, that a donor do an act that the law treats as delivery. The rules of contract formation that require more than a choice to engage in a bargain exchange transaction for a contract to exist are much more complicated. Lending a hand and mistaken gardener avoid these complexities by stipulating that performance has occurred. This avoids issues like whether there is an offer and acceptance, whether the definiteness requirement is satisfied, and whether there is a writing to satisfy the statute of frauds. The law could do without explicit rules of contract formation when the law only enforced a debt incurred in a half-completed exchange or a debt embodied in a sealed instrument. Back then, people could make an enforceable commitment to a future exchange by exchanging sealed bonds that were payable if they did not perform. Brian Simpson observes that the formality required in contracting was sufficient to protect men from fraudulent claims, but not so onerous as to produce any practical difficulty which would produce commercial inconvenience. It was easy enough to execute a bond, and impossible to do so without meaning to do so. The same may be said of the obligation to pay a debt incurred in a half-completed exchange. The performance requirement protects people from fraudulent claims and ensures that people choose to take the performance that is the basis for the debt in circumstances where they know or should know that payment is expected. The rules governing contract formation by an exchange of promises are more complicated. Under these rules, an actual or apparent choice to engage in a bargain exchange transaction, typically by offer and acceptance, is necessary but not sufficient to make a contract. In addition, the mirror image rule requires that an offer and acceptance match precisely. The definiteness rule requires that terms not be unduly indefinite. The rule against enforcing an agreement to agree requires that nothing expressly be left open for further agreement. For some transactions, these rules are backstopped by the statute of frauds requirement of a writing signed by the defendant evidencing the existence of the contract, for the contract to be enforceable. These additional requirements are imposed for good reasons, including shielding people from liability based on unintended and rash promises in the absence of performance, or in some contexts reliance, by the other party. Fuller refers to this as the cautionary function of legal formalities, like the statute of frauds. But an inevitable consequence of these additional requirements is that people who intend to make a contract may have their expectations disappointed. The mirror image rule illustrates both the positive and negative sides of these additional requirements for contract formation. On the positive side, when the difference in terms is material, the rule gives both parties an option to withdraw from an apparent but unintended bargain until performance occurs. On the negative side, the rule allows a party to seize on an immaterial difference in terms to escape an intended but bad bargain before performance occurs. Once a contract exists, contract law makes it possible for a party to be held to a term without their actual or apparent consent to the term. This is inevitable, for terms must be supplied to handle matters that people do not think and communicate about when they make a contract. Sometimes the law will enforce a term chosen by one party, though the other party did not actually or apparently consent to the term. The rules that apply to determine contract terms when an offer and acceptance have different terms and a contract is based on performance illustrate this. McGurn v. Bell. Bell's CEO and McGurn agree on all terms of McGurn's employment contract except the severance benefit. Bell's CEO tells McGurn he will agree to no more than a one-year benefit, which will pay McGurn half a year's salary if McGurn is terminated without cause in the first year of his employment. McGurn initially demands an open-ended severance benefit, but he eventually says he might settle for a 2-year benefit. Bell's HR people send McGurn a 2-page written and signed offer of employment with a 1-year severance term. McGurn signs the written offer but crosses out the 1-year term and writes in a 2-year term. McGurn does not call the change to the attention of Bell's people. No one at Bell notices the change until someone reviews McGurn's employment file after Bell's managers decide to terminate McGurn. The common law last shot rule generally resolves the dispute over terms in favor of the party in McGurn's position. In the case, the court held that the rule did not apply because McGurn signed and returned Bell's offer letter without calling the change to the attention of Bell's people. Had the court applied the last shot rule, it would have been an instance of a common occurrence under classical contract law and an occasional occurrence under modern contract law. A party's action, here, accepting performance, is deemed to manifest assent to a contract term when this is not their intent. The Battle of the Forms is a particularly blatant example of this because, in cases like McGurn v. Bell, it may be impossible to say that one party bears the greater fault for failing to notice and resolve a discrepancy in terms. Recognizing that a solution based on actual or apparent consent is unavailable in the Battle of the Forms defines the parameters of the problem. If the difference in terms is material and performance has not occurred, then the simplest solution is to allow the parties to withdraw from the contract unless one agrees to proceed on the other's terms. This simple solution is likely to be foreclosed if performance has occurred. For example, the buyer has accepted and used defective goods, resulting in a loss, and the discrepant terms address the seller's responsibility for the loss. In such cases, a court should try to resolve the conflict in terms by drawing on evidence of course of performance, course of dealing, and trade usage, and applying the rule in UCC Section 207, 2b. which enforces a term in one party's form if they could reasonably have believed that the other party would have assented to the term, if asked. These techniques cannot resolve the dispute over the severance benefit in McGurn v. Bell. The likely result under US law, assuming the court proceeds in this way and does not resolve the dispute by applying the last shot rule, is that the conflicting terms will knock each other out, and a court will apply the default rule. McGurn would lose because the default rule in the US is employment at will. Meanwhile, McGurn would be obligated to honour other terms of his employment contract, such as a covenant not to compete. Of course, this is not fair to McGurn. But it would not be fair to Bell to strip it of rights it bargained for, like a covenant not to compete. There is no solution to this problem that is fair to both parties if there is no reasonable basis for choosing one term over the other. The legal effect of a writing. Classical contract law versus modern contract law. McGurn v. Bell is a hard case because the parties thought about the severance benefit and tried to communicate their different choices. This section turns to the rules that give effect to a writing that expresses terms. Under these rules, a party who consents to a writing is held to predictably unread terms in the writing. This is true under both classical contract law, for example, New York law, and modern contract law, for example, California law, when a party gives no thought to the matter covered by an unread term in a writing. The disagreement between classical contract law and modern contract law involves cases where a writing does not reflect one party's intent and the other party knows or should know this. Classical contract law is likely to treat the writing as conclusive in such a case, while modern contract law will look through the writing. Section IVA addresses the parallel evidence rule and the duty to read rule. Section IVB addresses rules of interpretation. I will not address the enormous literature on the relative merits of the two approaches. If you believe that contractual outcomes should be based on people's will whenever possible, absent vitiating circumstances, then the modern approach is clearly superior to the classical approach in contracts made by people. The modern approach protects a party's reliance on a writing, but only when they are reasonably unaware that the other party had a different intent. The classical approach goes further than this and sometimes treats a writing as definitive, even though the writing does not reflect one party's intent, and the other party knows or should know of the first party's intent. The parallel evidence rule and the duty to read rule. When a person consents to a writing that expresses terms of a contract, they can be held to the terms of the writing, even if they do not read the writing. This rule applies even if a party is unable to read the writing, and even if the other party is aware of this. Obviously, under the rule, the object of consent is to the writing as an expression of contract terms and not to the terms in the writing. This rule is often referred to as the duty to read rule. The name suggests that people are expected to read a writing to which the rule applies. If this were true, then one could say there was apparent consent to a writing's terms. But people are not expected to read many types of contractual writings. Consumers are not expected to read form contracts. And it is well known that, when businesses exchange forms in transactions, business people often do not read each other's forms. A person cannot apparently consent to a term in a writing they predictably do not read. The duty to read and parallel evidence rules give people the power to use a writing to determine the terms of a contract, by getting the other party to consent the writing as an expression of their agreement. The duty to read rule makes a term in a writing part of a contract, even though there is no actual agreement with respect to the term. The parallel evidence rule limits a contract to terms in a writing, when parties consent to a writing as a final and complete expression of terms. Under both rules, the terms of a contract are determined by a writing as the expression of the parties' consent to their agreement. Robin Carr and Peggy Radin argue in a 2019 paper that the law should not enforce predictably unread terms in consumer form contracts, because an actual agreement with common meaning is central to the justification of contract. They liken communications regarding a prospective contract to a conversation between two people for the purpose of exchanging information, and argue that maxims that determine what is appropriate conduct in a conversation to exchange information should govern what is appropriate conduct in exchanging information about a prospective contract. The approach they propose would make it hard for a business to alter default rules in consumer contracts, because it would enforce an altering term only if a business person might appropriately raise the matter in a conversation with the consumer about the contract under maxims that apply to a conversation to exchange information. Carr and Radin claim that this approach was the position of contract law until the late 20th century. This is wrong. The rules of offer and acceptance under classical contract law did not limit matters an offeror could address in an offer to matters that were worth talking about. The law only required that an acceptance be a blanket acceptance of all terms in the offer. This rule enabled an offeror to set terms without having to talk about the terms with the offeree. And the mirror image rule and the last shot rule did not require an offeree to talk with an offerer about additional or different terms in a response to an offer. These rules enabled an offeree to set terms without talking about terms with the offerer. Carr and Radin mistakenly assume that the rules of contract formation and interpretation that apply to determine intent on matters people think and communicate about in making a contract also require that people think and communicate about a matter. In making a contract, for the matter to be covered by a writing, this has never been the law. While the duty to read rule was qualified, the qualifications only covered cases in which a party was affirmatively mistaken about the content or character of a document. There was no general qualification imposing a duty on the party presenting a writing to call a term to the recipient's attention or to explain the contents of a writing. Indeed, under classical contract law, the parallel evidence rule can bar enforcement of a term that the parties think and communicate about in making a contract. When the parties fail to include that term in a writing they adopt as an expression of terms, recall. Mitchell v. Lath. Mitchell and Lath sign a purchase and sale agreement for a home that does not include Lath's promise to Mitchell to have an ugly ice house on adjacent land moved. Under classical contract law, the promise is unenforceable under the parallel evidence rule, even if Lath knows Mitchell believes the promise to be part of the agreement. Technically, this result is possible because, in applying the rule, a court is instructed not to consider the strength of the evidence that the parties intended the term to be part of the agreement. Instead, a court asks if the term would ordinarily be in a writing such as the parties adopted. Modern contract law changes the result in Mitchell v. Lath. Under the modern parallel evidence rule, the court must consider the strength of the evidence of Lath's promise to remove the ice house. Mitchell will prevail under modern contract law if she can persuade the court that she reasonably believed that the promise to move the ice house was part of the agreement. Looking at it from Lath's perspective, he will prevail only if he can persuade the court that he reasonably believed the promise to move the ice house was not part of the agreement. B. Rules of interpretation. This section addresses rules of interpretation, specifically the different approaches of classical contract law and modern contract law to interpreting unambiguous writings. Putting this to one side, the rules of interpretation in contract law generally give effect to people's actual or apparent intent, much like the rules of consent in the law of self-defense, insofar as people think and communicate about the terms of a contract. Thus, contract law gives effect to the meaning that one party attaches to an expression, if they can show they reasonably believe that the other party attached the same meaning to the expression. Courts consider all relevant evidence in making this determination, in the absence of an unambiguous writing. Modern contract law has similar rules to determine intent when there is an unambiguous writing. I will come back to these rules after I explain the plain meaning rule, which is a linchpin of classical contract law's different approach to determining intent in such cases. The plain meaning rule instructs a court to give effect to the plain meaning of an unambiguous writing without regard to the party's actual intent. For example, under modern contract law, it is possible for people to use the term buy to mean sell. Under classical contract law, this is not possible if people use a writing. The premise of classical contract law is that, when people put unambiguous terms in a writing, they want courts to apply the plain meaning and not to consider the possibility that they intended something else. There are different versions of the plain meaning rule. I will focus on the version in the first restatement, which is not as strict as some. The restatement allows a court to stretch the meaning of a writing to interpret a writing purposively, so that a term makes sense in the context of the agreed exchange. The restatement also allows courts to consider evidence of surrounding circumstances, which include trade usage or local practice, in interpreting an unambiguous writing, that is, without a prior finding of ambiguity. But the restatement does not allow courts to consider evidence of course of performance or course of dealing, because this goes to people's subjective intent, which is irrelevant under the restatement when a writing is unambiguous. Again, people cannot use buy to mean sell. The plain meaning rule can yield a contractual outcome that is inconsistent with the party's intent when the language of a writing cannot be stretched to cover their intended agreement. Nanakuli Paving. Nanakuli, a paving contractor, purchases asphalt from Shell, an oil company, under a long-term contract that provides that the price is the posted price on the date of delivery. While this term is standard in the industry, the uniform practice is for asphalt and aggregate suppliers to price protect paving companies from price increases when a paving company commits to do work based on a lower price. Shell honored this practice in dealing with Nanakuli in the past, under this contract and a prior contract. There is a sudden, large increase in the price of oil and in the posted price of asphalt. New managers at Shell demand that Nanakuli pay the posted price, though this will inflict a large loss on Nanakuli because of prior commitments to do work based on the old, much lower price. Under modern contract law, a court can, and did in the actual case, require Shell to price protect because Nanakuli reasonably believed that Shell would price protect based on trade practice, course of dealing, and course of performance, that is. Shell knew or should have known of this belief. This result is possible because modern contract law instructs a court to protect people's reasonable beliefs about a contract, even if these beliefs are inconsistent with a writing. Classical contract law forecloses this result. The court could not consider the evidence of course of performance and course of dealing because this is irrelevant to interpreting an unambiguous writing. The court could consider the evidence of trade practice under the restatement. But classical contract law requires a court to resolve matters addressed by a writing by interpreting the writing, and the posted price term in the writing cannot be stretched to mean the price when the contract was made. Tacit intent and implied terms. This section addresses an objection to adopting a simple mentalistic definition of intent. The objection is that this definition ignores the fact that, when people communicate, they are understood to intend things that they do not think or say. For example, a parent who tells a babysitter to teach a child a game is understood to intend a child appropriate game. I argue that this fact is not a reason to reject a simple definition of intent for analytic purposes. Things that go without saying will be picked up by a rule deriving terms from context, as well as implied terms that cannot be described as intended or intended in this way. Some argue that a more capacious definition of intent is needed to explain implied terms. Adam Kramer takes this position in an account of interpretation in English contract law and its relationship to implication. Kramer explains that, under English law, implication in fact is a matter of interpretation and involves using pragmatic inference to supplement the linguistically encoded meaning, that is, the express terms. When the apparently intended meaning goes further than the linguistically encoded meaning. Simplifying a bit, Kramer's approach instructs a court to supplement express terms when it is normal for people not to resolve an issue by express terms. In such cases, a court is instructed to supply a term based on what it would be normal to intend on the particular issue, given the mutually known contextual circumstances. Kramer argues that a term so derived is intended because, when people communicate, the communicator intends the interpreter to supplement what they say when what they say gives the interpreter license to supplement. Langille and Ripstein argue that the fact that people are understood to intend things that go without saying when they communicate, together with the contextual nature of meaning generally, shows that implied terms can and must be derived from context and not from social values like autonomy and efficiency. The following passage connects the contextual nature of meaning to the English doctrine of frustration. The one aspect of the doctrine of frustration that does not survive this sort of understanding is the view on which courts appropriately respond to the lack of explicit agreement by resorting to some external standard of justice beyond the agreement of the parties. We can now see this view is entirely bankrupt. Having an intention does not depend on something coming before one's mind, and the only standard needed is the agreement of the parties, what they said to one another and what is made available to us by the world we live in. The Langille and Ripstein position is extreme. The orthodox account of contractual implication puts implied terms on a continuum, with the two ends being different methods or grounds for implying a term. Corbin calls these different methods interpretation and construction. Stephen Smith describes the different grounds for implication as terms that are implied by the court on the basis they were implicitly agreed upon by the parties, and terms that are implied on a basis external to the parties' agreement, such as to make the contract as fair or efficient as possible. In other words, at one end of the continuum, implied terms are derived from context, while at the other end of the continuum, implied terms are derived from social values like autonomy and efficiency. One could also say that, at one end of this continuum, implied terms are intended in the way the parent intends a child-appropriate game. Consider booking a room. Traveler books a hotel room over the phone, saying nothing about furnishings. An implied term requires that the room come with standard furnishings, such as a bed. Most people would say that, when traveler booked the room, they intended it to come with a bed, even if they did not specifically think this. This is intended in the same way that the parent intends that the babysitter teach a child-appropriate game. Kramer defines intent more expansively than this, to include cases like Blank check. Drawer gives pay a blank check. Kramer would say that drawer intends whatever amount pay fills in, so long as the amount is within the scope of the license granted. The amount pay fills in is intended in a different way from that in which traveller intends that the room have a bed, or that in which the parent intends a child-appropriate game. The babysitter has no license to teach anything other than a child-appropriate game. The babysitter has a license to select only among child-appropriate games. Some implied terms are intended in neither of these ways. In US law, these terms are described as default rules. Jacob and Young's A home construction contract specifies that the contractor, Jacob and Young's, use reading pipe. The contractor inadvertently installs some pipe of precisely the same quality, but from other manufacturers. The contract does not address this contingency. A default rule allows the contractor to recover the balance due. Because the substitution did not harm the homeowner, non-payment would result in forfeiture by the contractor, and the breach was not willful. Few people would say that the application of this rule is intended in the narrower way in which traveller intends that the hotel room come with a bed, or in the broader way drawer intends the amount that payee fills in on the blank check. If the application of the rule is intended or consented to, then this is in yet another way, which is that, when people contract, they intend or consent to. The application of whatever rules contract law supplies to deal with issues that they did not address. This brings me to the modest point I want to make, which is that the fact that people intend things that go without saying when they communicate, and intend terms without saying that when they contract, is not a reason to reject a simple mentalistic definition of consent for analytic purposes in contract law. Terms that go without saying will be picked up by a rule that allows terms to be derived from context, along with terms that are not intended or are not intended in this way. Terms that can be derived from context include terms that are intended in the narrower way in which traveller intends that the room have a bed. Terms that are intended in the broader way in which drawer intends the amount that pay fills in on the blank check, and terms that are not intended in either of these ways. For example, in Nanakuli paving, the price protection term is derived from context and, indeed, overrides an express term in a writing, even though it is difficult to describe the term as intended in either the narrower or the broader way. Lumping together these three cases, booking a room, blank check, and Nanakuli paving under the broad heading of terms derived from context, shows the sleight of hand in Langille and Ripstein's argument that, when it is possible to derive a term from context, this source should displace all other considerations. Surely, this is correct with respect to a term derived from context when the term is related to a person's choice in the right sort of way, because contract law generally tries to give effect to people's choices. But terms derived from context relate to people's choices in different sorts of ways, and some of these ways do not require displacing other considerations. For example, in Nanakuli paving, a court could reason that interests in finality and certainty justify enforcing the term in the writing, and not the term derived from context. Much more can be said about the relationship between intent, context, implied terms, default rules, and unintended terms in writings. The UCC prosaically describes context as course of performance, course of dealing, and usage of trade, and instructs courts that context may always be used to explain or supplement a writing. Another way of describing context is that it is what people do. Many default rules are not entirely based on what people do. Some, like the rule in Jacob and Young's, are made and changed in view of considerations like the institutional capacity of the legal system, the wealth of society, and a view about how people ought to treat each other. The allure of what people do as a source of implied terms is obvious in a case like Nanakuli paving, where the alternative is applying a term in a writing that was inconsistent with a trade practice honoured by the parties. What people do is a better guide to what they ought to do than an ignored term in a writing. The allure of what people do as a source of implied terms is much less obvious. If the alternative is a term adopted by a court to instruct people how they ought to treat other people in view of social values. But this is a subject for another day, for it is not about what people consciously choose. Conclusion. The main claim of this paper is that we will understand contract law better if we adopt a simple, mentalistic definition of consent and related states of minds, intent, choice, and belief. This definition shows that the most important objects of consent in contract law are consent to engage in an exchange transaction and consent to a writing as an expression of terms. This definition shows that consent plays a critical but necessarily limited role in contract. When people think and communicate about an aspect of a transaction, Contract law generally tries to give effect to their choices. But consent necessarily plays a limited role in contract because people do not think and communicate about many aspects of contractual transactions. Sometimes context can fill these gaps, but typically they are filled by default rules supplied by law or by unread terms in a writing.